a comprehensive act called the U.S. and Citizenship Act of 2021 that has been presented, but it hasn't been up for discussion, and it definitely has not become law. So whilst there is a law being presented, the benefits of that law has not yet been enacted. So I do not want to spend a lot of time discussing what's in that act, because legislation is something that is fluid. It will change before the final product actually comes out. So for those persons who do not fall within any of the categories that I outlined, I will just urge you to keep in touch with my Facebook page. I always post updates with regard to changing the law, any new provisions, any new benefit that comes out. We usually put a quick blurb on the Instagram account, Cordis Law. Okay. So if you have any questions with respect to your status, please feel free to drop a question in the chat room. And also, if you're on Instagram with WeApta's Instagram page, you can drop a question over there, or on their Facebook account. Feel free to ask a question. We will definitely get to those questions. Okay. Now, for persons who are outside of the US, we have quite a number of options to get persons here lawfully. And I wanted to expand on this because a lot of people think that there is only one way to come to the US, and that's with a visitor's visa, and then a lot of people end up here without status. There are several more avenues of lawful entry into the US when you're outside of the US than when you're here in the US. And so we're going to discuss those avenues. Primarily, you can bring in a relative. We all are familiar with the relative category, where you can bring in your spouse, your children. Sometimes it's minor children, sometimes it's adult children, and you can also bring in brothers and sisters if you're a US citizen. So those are very popular categories. The category that I want to dive into today is the employment category, or the work category, where you can come into the US and you're already authorized to work, which can lead to other benefits. Okay. So the employment visa has a limit. There's only 140,000 that is given each year. So when you're ready to apply for this visa, you want to get that application in by the first week in January, because rest assured, if you wait until May, June, the cap is probably almost exhausted. So for the first category, which is tier 1, these are persons that do not need labor certification. First, if you're a person with extraordinary ability in science, art, education, business, and athletics, you can come into the US. You don't need a job. You don't need labor certification. You don't need a job offer. You can just send in this application once they are satisfied that it's an extraordinary ability. Let me show you an example of extraordinary ability. Think Usain Bolt, okay? Usain Bolt, not the high school champ from, whatever high school you go to. That's not extraordinary ability. Your ability has to be in the category where you're probably the only person standing there, or there's just one other person with a similar skill set as you are. Okay, so it's a very, very high standard, but it's not elusive. It's just a high bar. So for persons who are educated, if you have 2 PhDs, 3 PhDs, you're up there, because the ordinary person might only have the master's degree or BA. So in education, you can show your high credentials. If you're a person in technology and you have a patent, or you have an app, and it's something just out of this world, then you will meet that standard of extraordinary ability to apply for the work visa. Okay, so if you have an idea or you have um, something in the art, you're an artist and you're renowned, everybody wants your drawings and your paintings, or you're, you know, a sculptor, you know, in high demand, more so than the ordinary person, you will be able to satisfy this bar. But bear in mind, it's a high bar, and you will have to demonstrate by documentary evidence that you meet that exceptional level of sciences or arts or education, even business. So somebody who has a business like Tesla, easy, nothing. So if you're in NIO, that business that is doing EVs in China, then check, you've met that, you know, extraordinary ability standard for a business. So if you have something that is out there that is just going to the stratosphere, everyone wants it, it's in high demand, you'll be able to meet this extraordinary ability of basically sponsoring yourself and coming to the US, getting work papers, and being able to conduct business with ease. The second tier within the first category is professors and researchers who are recognized internationally. Very important. You must be recognized internationally. So you must have been published in several journals. You must have had several mentions at the high medical journals or whatever educational scientific journals you're publishing in. It must be at the high caliber. You know, you want to be in Harvard Law Journal or the Harvard Business Review, you know, something from Oxford. Those high level international recognition is what you must demonstrate. So you can't just be a regular professor at university to qualify under this. So it might seem a little difficult, but there are people out there that can easily satisfy some of these criteria. They have published works, you know, literary people who do research, work on, you know, Caribbean diaspora, Caribbean dialect. There's so many researchers out there in the Caribbean that has a niche that they can tap into to get work permit here in the US. So please don't see it as something elusive. It's very attainable. And then there's multinational managers and executives employed by US companies or their affiliates overseas. So if you're working with a company like Microsoft, Google, Amazon, any one of them, JP Morgan Chase, you know, any of the big banks, they all have overseas locations, affiliate branches. If you're a high level executive there, a manager, an executive director, then you will be able to show that you fall within tier 1, but you would need to have a job offer. So this is where it turns a little. So if you're working with a company, the company has to be able to demonstrate that they have a job for you now here in the US. So with that job offer, you can submit your application for the work visa. And that's very easy. A lot of people come from the UK with the banks, and some of right now in the tech industry, Google, they hire a lot of people from overseas to come here and work in the US. And usually you get work authorization. Sometimes it's for 2 years, sometimes it's 3 years, limited status, so that you can work here with your company. So that is tier 1. That's the first group of persons who can come in under the employment visa category. Then we have a second group of people. These people need labor certification, which is a little bit more difficult. If you fall into this category, it's a little bit difficult to get this work visa. So for persons who have advanced degrees and persons with exceptional ability, you need a job offer, plus you need labor certification. So if you have a master's degree and 1 PhD, you still need labor certification because you don't meet the high standard for the first tier. You're in the second tier, and the company that is trying to hire you will have to show that there's no one here in the US that can do the job. So that's a whole different process, but it's an option that's available, and people do pursue it if it's something that the company is satisfied that only you can do, or they have already done their due diligence, advertised the job, no one has the qualifications but persons who are overseas, then they would they would have halfway already completed the labor certification process. So then we have persons who are skilled workers, professionals, and unskilled workers. You have, in order for you to get the work visa, you have to have the labor certification and your petition has to be approved before you can enter into the US. Okay? And for skilled workers, you have to have at least 2 years work experience in some category. So a lot of people would use this for the farmers and the farm workers, but because of COVID, a lot of people didn't tap into it last year. But this is the category that people would use to show that, oh, they can't find people to work in the US for the wage. So they can get the other people, to come into work at a lower wage. So they still need to do the labor certification. So you will need to have an employer to work with to submit your application in this particular instance. Okay. And then we have special immigrants. I think someone had asked about the special immigrants or the U visa earlier in the chat. So special immigrants, there are a lot of categories of special immigrant petition, but we're looking at the one under the work classification. So for workers under the special immigrant application, this would include broadcasters, which is people in the media. Now you have to be an announcer or reporter. You can't be the tech person, okay? So for broadcasters, you can apply under the special immigrants section of the work visa. You can also apply if you're a religious minister. I've done several of the religious minister application. You have to be an ordained minister. No quack, no one who calls himself a minister without proper certification will qualify. If you follow any religious doctrine or teaching, you must come within some sort of denomination, whether you're coming under the Catholic religion, any one of the umbrellas of the Protestant, whether you're coming as a Muslim or a Hindu, they all have certifications that they give to their leaders, their religious leaders, to meet the criteria. And this is, I always encourage persons in the church to utilize this visa. It is probably one of the most simplest ways to enter the US lawfully if you're overseas and you're in the church and you want to continue to do the work or the ministry, as they call it. You, however, would need to have a sponsoring organization here in the US. And that organization also has to be properly incorporated and structured and recognized at a federal level. So if you start a little church on the corner and you are not incorporated, you don't have your nonprofit status, and you want to bring a minister, you cannot bring that minister because you, the church, are not properly structured. So if you know anyone who works with, any of the big churches, Church of God, Presbytery, Baptist, any one of them, they all have proper structure here in the US. They all have their nonprofit status as 501c3s. And with that, they are eligible to bring religious ministers here in the US to work. Now, religious ministers, not limited just to the preacher or the person that preaches the biblical teaching. The minister is a very broad concept, and it can apply to any form of ministry. So if you're a dance minister, you're a music minister, you're an outreach minister, all of it will qualify you. You just have to make sure that you have the minister's ordination certificate. And there are a few other requirements, but in sum, that's what it is. It's a very simple application. You get work permit, Your family also is authorized to work, and it leads to the green card. So once you comply with the terms of the work employment, you become eligible to adjust your status and get green card. And that also goes for employees of U.S. government abroad and a host of other persons who work with U.S. companies, like interpreters and stuff, where you see those guys working in the Middle East as translators, putting their lives at risk and so on. When their job is ended, they're all eligible to come under this special immigrant visa because they would have completed the requirements of the terms of their contract. Okay, so those are some of the simple ones. And then we have the big one, which is most people will call the investor or the entrepreneur visa. It's something similar to a self-sponsorship. You have a business, you want to come here to the US. What do you need to do? Well, you better have a lot of money. That's the long and short of it. There are two categories that you can fall under if you want to come up as an investor. You have to be able to show that you can invest in the US and start up your business without borrowing money in the US up to the value of 1.8 million US dollars. This is a very high bar, and it's mainly for large corporations. Outside of that, there is a lower tier of starting a business without borrowing up to the value of 900,000 US dollars. If you can meet that criteria, you have to invest in certain rural areas in the US. So forget New York, well, at least not Central City, maybe upstate. But there are certain zoned areas that if you start your business in these areas, you only need to show $900,000 as an investment in the US. You also have to hire at least 10 persons. Those persons cannot include your immediate relatives, spouses, children, siblings. They have to be actual persons who are unrelated to you or your business, and you must maintain that business here for at least 2 years. And you have to be able to show by documentary evidence that you have the funds to carry the business through for the 2 years without borrowing money whilst you're in the US. So once you have your proposal in order and it's supported by your business finances to show that you've been doing business in the past, you have contracts, or you have the ability to source additional business to the tune of whatever your budget is for the next 2 years, you should be able to meet the criteria for the investor visa. Okay, and a lot of businesses are doing this, but of course you have to be able to show the 900,000 US dollar minimum investment. Okay, and if you're the beneficiary of this visa, your spouse and minor children also benefit. They get the benefit of coming here under that visa to work and live here for the duration of your visa. Okay. With regard to the broadcasters, the sad thing about it is there are only about 100 that's available each year. But if you start at the start of the year, you're most likely qualified to get the broadcaster visa because it's not a lot of people that usually tap into that one. So if you have any questions, feel free to drop it in the chat or drop it on Reactors Instagram account or Reactors Facebook page or on YouTube. We are open to answering all the questions that are posed. Someone asked if there's going to be a lottery for 2021. Usually every year at around September, they will put out the Diversity Visa Lottery. It's an annual allotment for visas. We anticipate that that will also come out this year. It was not done last year because of the pandemic. I'm not sure if they will increase the allotment this year because they should have excess from last year, but we should know in a few months whether that number will be increased or it will still be the same number that they offer each year. Let's see. Someone asked, how soon after getting your green card can you apply for citizenship? Okay, so the general question is 5 years. That's general. So the calculation of the 5 years is a little tricky. However, if you enter in the US as a permanent resident, it's five years from the date of entry. And that's easily calculated from the, you look at your green card, it will tell you issued from, and you calculate from that date, 5 years, 365 days being for a year. In terms of when you can actually send in the application, you can send it in at least 90 days before the end of the 5th year. Okay, so if your 5th year ended, or if your 5th year ends, let's say May 1st, you can send in your application now because it's within the 90-day period. For persons who would have adjusted their status in the US based on marriage, you do not have to wait 5 years. You can file for your citizenship within 3 years of getting your green card. So those are the only two distinctions. There are a couple of instances where even after the 5 years, you may not be eligible to file for your naturalization because you did not maintain continuous presence in the US or physical presence. So if you travel overseas, and we get this question a lot, I want to go overseas, I want to be gone for a year, is it going to affect me? Can they reject me when I come back in? As a green card holder, there is no automatic right to entry. We usually advise persons, if you're going to be outside of the US for 6 months or more, you should get a re-entry permit. In terms of your naturalization, if you stay outside of the US for more than 6 months, it breaks that 5-year calculation. And you have to start over when you come back. So that is why it's critical to not stay out for more than 6 months if you haven't gotten your citizenship. So we've had people who come and go, they come and they spend 4 months in the US and they're gone. They spend the rest of the time in another country, they come back, they spend another 4 months. And then when the 5 years are up, they're thinking they're eligible to apply for citizenship. You are not eligible because you haven't demonstrated the continuous presence requirement. You still have to show 2 things. You have to show an accumulation of 5 years, and you have to show that at a minimum 30 months prior to the presentation of your application, you were in the US. And the 30 months is calculated in your favor if you are not outside of the US for more than 6 months. So that's really why the 6-month marker is so critical to the calculation of your naturalization eligibility. Okay, so I saw another question in the chat. What if a person has temporary protected status? Are there any laws to protect community members from being deported? So temporary protected status is the law that prevents you from getting deported. It's only available to persons of certain territories, and I will call them out shortly. Your country must have been affected by some sort of natural disaster or political crisis or something going on where it's not safe, and they deem that persons here in the US are afforded extra protection. One of the protection is a protection against deportation. The second protection that you get is the right to get a work authorization. And once you get the work authorization, you are also entitled to renew that work authorization for a particular time. So for those countries that are eligible for a temporary protected status, we have, I think it's about 7 or 8 countries right now. So Burma was only added earlier this year. They added Burma to the list of countries, and these countries include El Salvador, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, Syria, and Venezuela, also Yemen. Venezuela was also added in March of this year. So if you're from Venezuela, I know Venezuela was affected because of their political unrest. If you were here in the US at the time of the protection of the TSP status, you are now eligible between now and 2021 to submit your application for temporary protected status. What it does is gives you work permit and you can stay here without being deported. And then you also can reapply. The other thing is I wanted to point out, yesterday, our Congresswoman Yvette Clarke also asked Congress to afford St. Vincent and the Grenadines the status of temporary protected status. That would allow Vincentians who are here in the US and who cannot return home because of the current Soufriere volcano to remain here, get work authorization, work to support themselves, and not have to worry about being deported when their 6 months or whatever authorized stay expires or is about to expire. So I'm going to keep a keen eye on that piece of proposal to see if there is any traction and if our Congresswoman Yvette Clarke, the amazing Yvette Clarke, can bring this to fruition so that our Vincentian colleagues and family members can get this benefit. Okay. So let's see. Melissa, do you have any questions on the WIAPAS page that you want to ask? Okay, I think you're on mute. So okay, I'm going through to see if we have any other questions. If you have, okay, someone says, my son will be 18 in September, but July will be 5 years. Okay, I do not understand the abbreviation. Can he still get his citizenship under his dad? Okay, are you a citizen? So for children, if both parents are US citizens, then you don't need to file a citizenship application. You can just file for a passport, a US passport. It's cheaper, it's quicker, it saves you a lot of time. If one person is a US citizen, then yes, if he has had his green card for the requisite amount of years, then he is eligible to apply for his citizenship. Bearing in mind, there are some limited exceptions where a child can get a certificate of citizenship and they'll have to apply for naturalization certificate. So it's a little different process, and it will all depend on the facts of your son and his relationship with his dad, and when the dad became a citizen, when the son became a green card holder, stuff like that. So I think that's Sharon. And Sharon, just send me a message on Cordis Law, and I'll get back to you with any more specifics that you may need. Okay. So if I stay outside of the US, it's less than 6 months. Would that stay affect the 5 years? The answer is no, it wouldn't affect your 5 years. It wouldn't break the time for the continuous presence requirement, but it will reduce the number of days. So when you're calculating the 365 days for each year, it will be reduced by the 4 months that you're out. But if the 4 months that you were out is not within the first 30 months from the date of your application, it will not affect you. So it's just a little numbers calculation that we have to run to make that determination.
We actually have one question.
Yes, Melissa, I'm listening to your question.
Oh, sorry, but I don't know if I was lagging for a little bit. I'm going to read the question verbatim. It says, can an adult child over 21, so can an adult with a U.S. citizen parent adjust their status in the U.S. without leaving?
Okay, so maybe. And I say maybe because the circumstances for everyone's case is different. Generally, the answer will be no, but there are certain waivers applications that you can present and can get approved, but it's extremely difficult to get the waiver approved because you have to show extreme hardship to the U.S. citizen, not to you, in order to get that waiver application approved. So if you already have an approved petition and you want to go to the next step before you can adjust your status, you have to file for the waiver. And the waiver has to be approved, but there's no guarantee on the waiver unless, for example, you have a parent who is critically ill and you're the only child, then you would have medicals to support that. But there are also other instances, it don't have to just be illness. There are also other instances that you can satisfy that criteria. But in order to do so, with some limited exceptions, you definitely need an approved waiver.
Thank you for that.
You're welcome. Okay.
Last question I saw in the on the Facebook page.
Okay.
So
I don't see any questions on my Instagram. I think I answered most of the Instagram questions. I think I answered the questions in the chat. We've touched on most of the visas that are available. I also want to just point out for our Vincentian family, there is something called a humanitarian parole that is available. If you see that how your country is devastated, you can basically self-petition the U.S. Embassy where you are to ask for that right to enter the U.S. under the humanitarian parole. An organization can also put an application in on your behalf, or any person in the U.S. can put in an application on your behalf. You just have to document the circumstances, and we're all familiar with the circumstances, quite known. So if it is that you are outside of the U.S. and you have a relative or an immediate relative who can file a subsequent application for you, this might be something you can look into. It does not give you green card status, but it will give you a limited time to be in the U.S. lawfully. Okay. And once you get here, if you can exercise any of the other avenues to adjust your status or to get someone to sponsor you to remain and to obtain the green card. Bearing in mind that we all are sitting waiting for the U.S. Citizenship Act of 2021 to be passed, so that there is a path to citizenship for all the undocumented persons here in the U.S. And if you are into politics or following politics, or at least interested in having a change in the immigration policy, I want to encourage you to call your congressman from your state and lobby with them, and call them every day and ask them what's going on with the U.S. Citizenship Act, because we need to take an active step in our own advancement. And as a not undocumented migrant, you can call. There's no restriction on calling. You don't have to identify yourself. You can ask for that person to make a representation to have that act presented and subsequently passed. So I'm looking to see, we're coming to a close of the hour. So if there are any other questions, please let me.
Quick announcement. If you're in the Zoom, please type your questions in the chat room. Thank you. Okay.
Okay, I don't see any additional questions being asked. Oh, I think there's just one. I joined late. Are there any updates with the public charge. There is a stay with respect to the public charge. It's no longer being implemented. If you had submitted your form that was required under the public charge between November, December of last year and March of this year, USCIS will no longer review those documents. Going forward, the public charge is not being considered for persons seeking to adjust their status. Okay, and just as a side note, for those persons who are interested in applying for citizenship, currently the fee is the $640 fee. The proposal to increase the fee to $1170 has been stayed. This is just for a time being. I'm not sure when that stay is going to be lifted, but if you are desirous of getting your citizenship application done, now would be the time. $640 is the USCIS fee. If you have any questions, please feel free to visit our website, melniacortislaw.com, or send us a message on Cortis Law Instagram. Also, WIACDA has a platform to send any questions that you may have from their Instagram account. They're also on YouTube and Facebook as WIACDA. I want to take this opportunity to extend my sincere thanks to the board of WIACDA for having me to host and commence this inaugural Law and Use series. Thank you, Melissa, for facilitating us this morning, and much thanks to TJ Spice for moderating on the technical side. I also want to extend a heartfelt thank you to Karen and Natasha and all those who were instrumental in having this initial program off to a great start. I want to encourage each and every one of you to join us on the third Wednesday of May. We will be here discussing the rent situation in New York under COVID. If you're a tenant and you're being harassed by your landlord with respect to paying the rent, we will have persons here from the court to answer questions. Also, we will be talking about commercial landlords and their position with respect to paying their mortgages in the situation where there is a stay that's in effect. So if you have any questions or you want to hear more about the rent situation here in New York, please join us on the third Wednesday of May. We'll be discussing the tenants' rights and reform under COVID. So
hi, this is Maria Smith. Before we go, I had a quick question. I apologize. I was on mute. I work with some clients that some of them are, their spouses might have applied for them, but a few of them might, their spouse, they're separated. And basically based on spousal abuse and those things, they want to know if they can still continue with the applications, just based on the premise of, their spouse being very abusive to them. Can they still get through?
Okay, just to clarify, when you say continue with the application, did the spouse petition for them or did they petition as a domestic violence spouse?
Well, the spouse petitioned for them, but the spouse is, threatening not to continue with the application. The abuse is taking place. So I don't know where they stand with that.
Okay, so immigration has a special immigrant category for victims of domestic violence. They can self-petition, and I want everyone to know it's not limited to women, both men and women. If you're a victim of domestic violence, you can self-petition. You can simply withdraw the application on your spouse and present an application on your own behalf using the abuse as the basis for the application. Now, it's a very technical application. There are certain timelines that have to be followed. You have to have been married for a certain number of years, just to protect yourself. So I would suggest if the person has a current and a serious situation and they want legal advice, they should just reach out to me on my website, or you can send me a direct message on Instagram. But just note, and you can let them know that they need to file a new application under the domestic violence section that will give them the right to control the application process and the outcome. They also have to have documentation to support the abuse. You have to have police report. You can get affidavit from friends and family outlining instances of abuse. You can also have photographs of bruises. If you have recordings of the abuse, you can have those transcribed, or if it's a video recording, those also can be submitted with your application. You must, however, be able to substantiate the abuse. Okay. I hope I was able to answer that question for you, Ms. Smith.
I think we have one other question in the Zoom. If you have a question in the Zoom, can you just type it in the Zoom chat room? Thank you.
Okay. So we're waiting to see if anyone else is submitting the questions. Whilst we wait, I just want to give a quick overview on the naturalization requirement. I know we touched on the 5-year presence, but you must also be able to show that you paid your taxes for 5 years. They will want to see your taxes. You also have to show that you have good moral character, and that's usually a little tricky situation to satisfy that burden. Some people want to know why they got denied, because they can show good moral character. There are certain instances like that are permanent ban, and then there are some conditional bars to naturalization. Permanent ban includes like felony and anything that involves crimes against the country. But with respect to the conditional bars, it's a very broad category, and people have to be mindful of the fact that simple things that they don't think might be a bar to naturalization really is. And I just want to go over some of them. If you've been incarcerated, that's a conditional bar. You have to, speak to an attorney before you send in your naturalization application. Polygamy is also popular. When you get married to one person, then get divorced, go get married again, and now trying to get a citizenship, they will see that, and that's a bar to naturalization. So just bear these things in mind. If you also fail to pay child support, yes, they can deny you your naturalization application. Also, if you have limitations with respect to reading and understanding and writing English, you can also be denied. But most of these are overcomable. That's why they're called conditional bars. You can be prepared to address those issues. Just contact our office or contact me via Cordis Law on Instagram.
I don't know if you're still open for any questions, because I know we want to be mindful of the time, but there was one question that came in from the Facebook page. And I'm reading the questions verbatim. How long will it take a citizen to sponsor for sponsorship for their wife?
Would that person be here or outside of the U.S.?
They didn't clarify, so maybe if you want to tell us if there is a difference. So what is the difference?
Well, yes, the difference is it's time and process, really. If you're outside of the U.S. and you're petitioning for a spouse, if the petitioner is a U.S. citizen, that determination will be done within a year. And thereafter, you will go through what is called visa consulate processing to get you up to the U.S. That process in itself takes about another year. So on average, it will be about 2 years. If you're here in the U.S., you can file all the documents at the same time, the petition for your spouse, and they will just get what is called a conditional green card for 2 years. And thereafter, they can remove the condition and they'll be eligible to file for their citizenship. So the timeline is just different, and the process is different also. Someone asks, if you married for 4 years to a citizen and separate for 2, what can you do even if you didn't start any paperwork? Okay, I'm taking the paperwork with me to adjust your status? Well, if you are not the victim of domestic violence, you're not eligible to self-sponsor. So if you have been separated from your U.S. citizen spouse, you would be encouraged to consider a reconciliation in order to get the petition filed. It's always critical to know what your rights are. So if you've been married for 4 years, you definitely don't want to wait until year 4 and not put in your immigration paperwork. I understand that there are constraints in terms of financial restrictions and limitations for families, and they're not able to afford to put in that application. But if you're separated from your spouse, you cannot self-sponsor. Only persons that can self-sponsor those who have been the victim of domestic violence. And I want to just highlight that people should not file false claims of domestic violence, because it also affects the petitioner. They can lose their job because USCIS have a way of, tapping in all bases. They check with the job to see if there have been any instances of abuse reported by the spouse to the employer. And then they sometimes communicate that the spouse is alleging abuse. And if you're working with children or you're working in an environment where you have to maintain certain decorum and certain attitudes, you can also lose your job should your employer get wind of the fact of abuse. So if you are separated from your spouse, you must at this time be able to probably get a child. If you have an adult child, 21 years old or older, that child will also be eligible to submit a petition on your behalf, and you can get adjustment of status from that. Otherwise, I would encourage you to seek a reconciliation with a view to regularizing your status based on the fact that you still, in all circumstances, with a reconciliation, would have had a bona fide marriage. I see another question. If the person cheat and get a child. Okay. Wendy, please come and help these people out. This is an immigration forum. We do not provide, oh my goodness, do not provide any guidance with respect to how you want to deal with cheating spouse. At the end of the day, if you're applying for immigration benefit, you must be able to show that you have a bona fide marriage. Now, marriages come in all kinds of ways and shapes. Not everybody can say they have a perfect marriage. Not everybody can say that, their husband never cheated on them or their wife never cheated on them. It's all a question of what you do with that information. If you're determined to get to the end of the immigration process, then you, as the beneficiary on the petition, have to take steps to ensure, if it's something that's priority to you, that those goals are attained. And at the same time, we would say in the Caribbean, when your hand in dog mouth, your party head. That's my advice. What's the next question?
We have one question from the Facebook page. And again, I'm reading the question verbatim. My application was filed over a year ago, but no interview. And this is a follow-up question from a viewer who was asking how long it would take for citizen sponsorship for a wife. So the follow-up question is, the application was filed over a year, but there has been no interview thus far, no interview appointment thus far.
Okay, so with the COVID implementations, immigration stayed their processes, and they only resumed operation, I think it was in September. And at that point, it was very minimal. They were only doing administrative work in terms of reviewing mail and, scanning their mails and sending out information for additional evidence. I have seen, as of this year, they have begun to schedule interviews, but those interviews for adjustment are for persons who would have filed in 2019. So if you were filing in 2020, I would say you probably have to wait close to the end of this year before you get an interview date because of the backlog. Because during the close down, people are still sending in applications. And then those persons who would have had interviews had to have those interviews rescheduled. And people who are also waiting for interviews also have to get dates ahead of you. So I would definitely say closer to the end of the year in your instance, early next year, if not.
And I think that was the final question that we had from the Facebook page.
Awesome. Okay, so I had given my little thank you before. I also want to thank all of the persons who have tuned in, whether it's on Viagda's Facebook page, their Instagram page, their YouTube, or my Cordis Law Instagram account. We appreciate your support. I hope that we were able to answer all your questions. As a follow-up, if you have any questions that you want to ask, you can always follow my page on Instagram, Cordis Law, and send us a direct message. We will respond. Or you can schedule an appointment from my website, melniacordislaw.com. We have appointments that are available virtually. You can be anywhere in the US or outside of the US. We will entertain you by way of video appointment or telephone appointment. And the cost is reasonable. So if you have any immigration questions or concerns, we are here to answer you. We are here to assist you, and we are here to get you your immigration benefit. Thank you again to Viagda. Do follow their page. Follow Represent We, and thank you, Melissa. They are an advocacy group that promotes immigrant representation here in New York. Thank you again, once and all, and have a great evening. We will see you in 3 weeks for our rent forum.
Thank you, everyone.
Thank you, ladies and gents.